All right, we're back on the record on State versus Loyd. Mr. Loyd is present along with his attorneys. State Attorney's Office is present. Let's bring in the juror in seat number 25, and it's juror number 27.
I gotta go one quick. Make yourself comfortable right there.
Welcome back, sir. All right, sir, did anyone talk to you? Did you hear anything about the case at lunch, anything like that?
No, ma'am.
All right. We're going to be asking you a series of questions. All we need you to do is to tell us the truth. There's no right or wrong answers to these questions. There's just what you think and feel, okay? Let me start with, you told me you haven't heard anything about this case, correct?
Just what you've told us Friday and today, ma'am.
And today?
Yes, ma'am.
Right, all right. All jurors are required to presume that Mr. Loyd is innocent until and if the state can prove he's guilty. As you sit here right now, can you do that?
Yes, ma'am.
All right. Can you tell me what your feelings are, your position is on the death penalty, please?
I'm open. I don't have any decision one way or the other. I guess I've never been in a situation where I've had to think about it or decide.
Okay. Are you opposed to the death penalty in any way?
No, ma'am.
Are you someone who believes that in certain cases the death penalty should be automatic?
I would say whatever the law or whatever fits based on the guidance and the information we're provided, I guess that would determine the decision.
Okay. In this case, if Mr. Loyd was found guilty of first-degree murder, you would then enter the penalty phase of this, and that's when you address the issue of life without parole versus death. So you would, as a juror, you would be asked to listen to the evidence the state presents as to aggravators, reasons they believe that Mr. Loyd should be sentenced to death. The defense presents evidence of what we call mitigation, which is the reasons they believe that Mr. Loyd should be sentenced to life without parole. At the end of all the evidence, I'll give you the jury instructions on what you're supposed to do with all of this, but then you go back into the jury room with your fellow jurors and you have to weigh the aggravators and the mitigators. And we encourage you to talk about it among yourselves, but in the end, each juror has to make an individual decision as whether you believe life is the appropriate sentence or death. In order for a court to be able to impose a death sentence, the jury must vote for death unanimously. And any juror can vote for life at any time. And, you know, if one juror votes for life, it's life. You understand that?
Yes, ma'am.
You with me so far?
Yes, ma'am.
You have to be able to have an open mind about listening to the aggravators and the mitigators. Do you believe that you can do that?
Yes, ma'am.
At this point in time, do you have any issues or any concerns about your ability, if the evidence led you to believe, and all the facts and everything you'd heard led you to believe that life without parole was the appropriate sentence, would you have any problem imposing life without parole?
No, ma'am.
And if the evidence and all the facts and everything you heard led you to believe that death was the appropriate sentence, would you have a problem voting for death?
No, ma'am.
Mr. Loyd, as I told you, has raised the defense of insanity. And I briefly read a little bit of the instruction to you. Do you have any automatic reaction to a defense of insanity?
No, ma'am.
Is that something that you could listen to, and if it was proven, you could vote for it?
Yes, ma'am.
Right. And then lastly, you heard me tell you that Mr. Loyd was convicted of the shooting of Sade Dixon and her unborn child.
Yes, ma'am.
I'm telling you that that information cannot be used to determine whether or not he's guilty of this case, in this case. You understand that?
Yes, ma'am.
I'll explain to you later on, if you're on the jury, what that information can be used for. Can you follow that instruction?
Yes, ma'am.
All right, thank you, sir, very much. State, you may inquire.
Thank you, Your Honor.
Regarding your views about the death penalty, seems like you're neutral either way, kind of right in the middle.
Yes, sir.
Okay. Some cases it may be appropriate, some cases it may not.
Yes, sir.
All right. The judge asked you a question a few minutes ago about whether you felt that certain cases automatically deserve the death penalty. You said you'd basically follow whatever law you were instructed. Okay. And you understand in Florida, there is no such thing as an automatic death penalty type case. Okay.
I would, if you say so.
Okay. In order for the death penalty to even be eligible, certain additional factors have to be proven to you beyond a reasonable doubt that make this murder more egregious than a typical first-degree murder. And typical murder is not a really good term, but I think you might understand where I'm coming from.
Yes, sir.
Okay. Even if you found in your heart that this murder, you were angry about this murder, that there were a whole lot of aggravating factors in your mind,
Overruled. Go ahead.
would you still be able to listen to the mitigating evidence to determine if it's appropriate in this case?
Yes.
Oh. Overruled.
So even if we're shown to you that this is a premeditated murder, not accidental, would you still be able to listen to all the evidence, especially the mitigation, before you make an ultimate decision in this case?
Yes, sir.
You've heard the term aggravating factors, and those are factors that are limited by the statute itself, by the law. And the judge will tell you, if we get to that point in this trial, what those aggravating factors are. And you can only consider those aggravating factors that she tells you are appropriate. Can you do that?
Yes, sir.
Can't consider other stuff that you may think is bad. You have to focus on these aggravators if they're presented to you.
Yes, sir.
All right. As far as mitigating factors, those are factors that tend to show that life in prison would be the proper punishment in this type of a case. Okay? Would you be able to listen to any and all mitigating evidence presented to you and truly consider it before making a decision in this case?
Yes, sir.
All right. If at first glance or first blush you hear some evidence, and this is not the time for us to talk to you about the details and the evidence that relate to aggravating factors and mitigating circumstances. That's later. So even if at first blush you may hear something that is presented as mitigating to you, and without hearing any evidence, you might be thinking, well, I don't know if that's really mitigating. You agree to hold off your judgment until you hear all the details and all the evidence dealing with the aggravating or mitigating factor. Yes. Do you think that Mr. Loyd deserves to have a jury who will listen and consider all mitigating evidence before?
Yes, sir.
If I were to stand up here and start rattling off 50 different mitigating factors that could possibly come about, am I correct that your answer would be, yes, I would consider all the evidence before I make the decision? Yes. Okay. Now, after hearing the evidence about an aggravating factor or a mitigating factor, you can come to a variety of different conclusions. Say that it has been proven. You can say it has been proven, but I don't think it's very important in my decision-making process, and give it little weight. Or you can say that's a really important piece of information and give it a lot of weight. That is up to you. Do you have any religious or moral beliefs that would interfere or make it difficult for you to make a decision such as the proper punishment in this case?
No, sir.
Okay. The decision as far as whether what death penalty is appropriate in this case or life in prison is appropriate in this case is an individual decision that you would be asked to make, okay? Knowing if one person on the jury votes that life in prison is the proper punishment, that ends up being the sentence in this case. The life will be imposed as the punishment in this case. It would require all 12 jurors to decide that the death penalty is the appropriate punishment for that to be a sentence in this case. Do you understand?
Yes, sir.
Because it has to be a unanimous verdict if the death penalty is to be imposed, if the 12 of you come back and vote death penalty is proper in this case, obviously it's going to be unanimous and everybody would know you voted for it. Knowing that everybody would know you voted for it, would you be able to come into this courtroom, raise your hand, and tell the judge that this man deserves to die for what he did if you felt that was the appropriate punishment in this case?
Yes, sir.
Now, that's an easy question to answer. Maybe if you're hanging out with friends, talking on, at a party or something, a little different context when you may find yourself in that specific situation. Do you think you can do it?
Yes, sir.
Okay. Switching gears a little bit, the judge mentioned the defense of insanity will likely be an issue in this case. I'm going to ask you a few questions about your feelings toward mental health issues. I don't mean to be deprived, but obviously I think you can tell it's an important question to ask. Do you or any close friends have any experience dealing with significant mental health issues?
That I'm aware of.
Do you think that mental health issues are a real thing in the world, or do you think it's kind of made up or it's bogus?
No, I would definitely say that.
Okay. Would you be able to listen to the evidence in this case dealing with whether a mental health issue exists before you make a final decision as far as whether insanity has been met?
Yes.
Okay, you could listen to all the evidence before you come to that.
Yes, sir.
Is there anything in your background or your life that makes you feel you would not be a good juror in this type of a case?
I don't believe.
Okay, you can be fair?
Yes, sir.
Thank you, sir. Anything else?
Thank you, Mr. Rexler. Mr. Linneman, you may inquire.
How you doing, sir? Good. What kind of work do you do?
I work at a department.
In the city of Orlando, or?
State of Florida.
Okay. And specifically, what kind of work do you do?
I'm the regional supervisor for HIV prevention, counseling, testing, and linkage.
Okay, great. And is that a lifelong working for the health department? Have you been doing that most of your adult life, or?
No, sir. I was a mechanical engineer up until 2012.
And if I may, and if it's private, we can talk in private. Why did you switch fields?
I relocated from Boston to Florida.
Okay.
It was a position at job.
Now, I guess when you first came in the courtroom and were asked some questions, and even now, it seems like you're very structural in terms of following rules. Would you agree with that?
Yes.
Okay. Because you didn't reference to what the rule was. You said, if it's the rule, I'm going to follow it.
Yes.
Would that be fair to say?
Yes, sir.
Okay. Why do you think you're that way?
I just think it's who I am as an individual, as an engineer. As a supervisor, decisions are made based on policy procedure. It's just how I've been professionally, how I've been my whole life.
Okay. And where does, emotion fit into that?
And I think emotion comes to personal relationships. I don't look at it as business relationships.
Okay. You're obviously dealing with a lot of tough stuff as a supervisor in that capacity with the health department, right?
With emotional? I'm not sure what you mean by that, sir.
Yeah. With emotional, are you dealing with day-to-day people who are dealing with that, or you just supervise people who supervise them?
I supervise the staff that link people to care with testing and services. So I don't deal with clients directly anymore.
Okay.
I used to. I was a medical case manager for about 3 years. So now I don't deal with staff. Now I don't deal with clients directly. I deal with staff directly.
And what did you do as a medical case director?
Link clients to services. So if somebody was diagnosed, we would link them to care and services.
Okay. Now, I think you had said you really never thought about the death penalty before today, kind of. Is that right?
Yes, sir.
Okay. So obviously you had a little bit of time to reflect that this was a death penalty case because you found out on Friday, you had the whole weekend, obviously today, while you had been waiting. Has anything popped up in your mind in terms of thoughts about this being a death penalty case? Not at all.
I could just sort of take it a day to come. I'm not sure that I would make it to the trial, so I guess I would decide as things went through. I don't know enough about the case to make decisions.
And I'm not asking you about the decision you would make. We're not allowed to really do that. What I'm asking you is, what are your thoughts about the death penalty?
I guess I would about the situation, whether it's warranted or not warranted, or whether it is applies to the situation or not applies to the situation.
Okay.
I've never been in a situation where I had to consider it or be part of it.
Right. So some people, you ask that question, they say, I'm completely for it. Some people say, I'm against it. Some people have opinions about it one way or the other. Do you have any of those things going on?
I'm really neutral. I'm not educated on it, but it's never been part of any decisions I've ever had to make it's never impacted me, so I've never got involved in the decisions.
The fact that you would have to make an individual decision on someone's life, how do you think about that?
I think that if it was, or if it was if it applied to that situation, then I would make that decision or determine the decision after I had all the information to see if it applied and was warranted.
Okay. But you understand the application and the decision whether it's warranted or not all comes down to you personally. It's an individual process.
Yeah.
You don't have any problem dealing with that?
Not yet.
Okay. When you say not yet, what do you mean?
I mean, so far in my life, I don't have an opinion on one side or the other, so I would have to have the information.
Okay. And you didn't have any strong feelings about the death penalty where you believe someone should always get it? The death penalty, is there a circumstance you believe that someone should always get the death penalty? Okay. Your opinion, not anyone else's, your opinion. Like, you see a mass murder. Is that something that you would think someone deserves the death penalty?
No, because there can always be extenuating circumstances.
Okay, great. Now I'm going to ask you some questions about the death penalty itself. Now, the way it works in Florida is that if Mr. Loyd is convicted, and only if, of first-degree murder, then we would go into a second trial with the same jurors, and you would be given a set of instructions on what the law is, as you've been told by the judge, and you will have to listen to evidence put on by the state and the defense and make a decision. Following me?
Yes, sir.
Okay. So the law says your decision goes kind of like in this order. Number one, you have to decide whether one aggravator, all of you jurors have to decide whether one aggravating factor was proven beyond a reasonable doubt for you guys to go forward with the death penalty issue. You understand that?
Yes, sir.
It's still an individual's decision to you, as is everything in the second part of the case, but as a group, you have to agree.
Yes, sir.
You understand that?
Yes, sir.
That's the only time as a group you have to agree in the penalty phase. Everything else is on you. And even though the state talked about this concept that all the jurors have to come back to have a death sentence unanimously, that's 12 individual decisions that are made. Understand that?
Yes, sir.
One of which is yours.
Yes, sir.
So the next step is mitigation. You have to look at, actually the next step is you have to look at the aggravating factors. If there's more than one, you have to decide on which ones you individually believe have been proven beyond a reasonable doubt. Okay?
Yes, sir.
You put those in a little compartment. Next thing you do is you look at the mitigation. Mitigation could be anything. And that has to be proved by a lesser standard than beyond a reasonable doubt. And then once you decide that, just like you decided the aggravators, you have to give the aggravators a certain amount of weight, whatever you feel the weight should be. And with the mitigators, you have to give the individual collectively a certain amount of weight. How much value those are to you. Do you understand so far?
Yes, sir.
Okay. So then you have the aggravators, the mitigators, and then you weigh those yourself individually. If you believe the mitigation outweighs the aggravation, you always have to vote for life. It's an individual decision, but if you believe that the mitigation outweighs the aggravation, you have to vote for life. Do you understand that?
Yes, sir.
If you believe the aggravating factors outweigh the mitigating factors, you may vote for death, but you are never required to vote for death. The legislator has said, and you will hear a jury instruction, that you are never required to vote for death in any circumstance. You understand?
Yes, sir.
Once that's placed in front of you, the aggravators versus the mitigators, then you have to make a decision. If the aggravators outweigh the mitigators, the next decision you have to make is whether you are going to vote for death individually. Understand that?
Yes, sir.
Okay. So now we've talked a lot about how individual this is. How do you feel if you believe you reached one verdict, one way or the other? How do you feel about the fact that someone may try to bully you into changing your opinion?
I'm an independent person. I've never been bullied.
You're not going to allow that to happen under any circumstances.
Not so far in my life.
Okay, and you understand that there is no bullying that's allowed in the jury room. You understand that?
Yes, sir.
And would you protect another juror, whatever their opinion is, who's being bullied, from being bullied?
Yes, sir.
Okay. So now I want to talk to you about some mitigating factors. Some people could consider them, some people can. So I'm going to give you just some general ideas. May not belong to the case at all, okay?
Okay.
Do you think that, generally speaking, racism is a mitigation that you can consider?
Can you clarify? I'm not sure what you're asking. If you're asking me what I consider somebody's race?
No, racism. Like someone's treated because of the color of their skin, their ethnic.
That somebody's treated differently?
Yes.
Yes, I would tell you people are treated differently based on their ethnic backgrounds.
Okay. Would you be able to consider that as a mitigating factor?
Yes.
Okay. Mental health, generally, would you be able to consider that as a mitigating factor?
If you're meaning that it can, I guess, explain a little bit more what you mean by mitigating factor again.
Okay, a mitigating factor is in your decision-making process to decide life or death. The state gets to provide a certain set number of aggravators to you, which you can consider, and the defense gets to present unlimited number of mitigators, which you can consider.
So cause and effect.
No, it's not cause and effect. You're taking the mitigators on their own. You're looking at each one. You're assigning it some sort of weight, and then you're assigning all of them collectively a weight. And if that weight outweighs the aggravation, then you have to vote for life.
Yes.
So if we're talking about something to do with mental illness, it may be something specific. It may be something from history, current, so forth and so on, and that's presented to you. You would be able to consider that as a mitigating factor.
Yes.
And going back to the mitigators, you would be able to give it weight.
Yes.
Correct?
Yes, sir.
Okay. How about trauma? Would you be able to consider generally trauma that someone suffered in their life?
Yes, sir.
Okay. Now, the judge told you clearly, without question, that in the first part of this case, you already know that Mr. Loyd has been convicted of first-degree murder of his ex-girlfriend and an unborn baby. You know that as a fact, okay? He has a conviction for it. She told you absolutely you cannot use it at all in the first part of the case. You understand that?
Yes, sir.
My question is, there are some people who hear something like that, and even if they're told they can't consider it, would not be able to not consider it. Are you one of those people?
I would have no problems not considering it, if that's
Okay.
what you're asking.
Thank you. Now, we talked about respect being an essential part of the second part of the case. Respecting jurors, respecting each other, respecting decisions, and you said you can do all that.
Yes, sir.
There's a certain part of the case in the penalty phase, if we should get to that, it's entitled victim impact. And the legislator has decided, and it's incorporated into the jury instructions, that a juror gets to hear from family, friends, or someone else in the victim's life about the uniqueness of that person. It's an absolute requirement. You will hear it in this case. The thing about that is, the legislator and the jury instructions tell you you cannot consider that on the issue of being an aggravating factor and death. So although you can consider it, it has to be separated from your decision to vote for life and death. Can you do that?
Yes, sir.
Okay. One second, Judge.
Sure.
Hold on. One more area, and we'll be done, sir. You, and I know that we've talked about that you're very structural in your thinking, and sometimes in your speaking. So you had said earlier about the death penalty that you need to learn about the situation. What are you talking about?
I guess I would need to learn on when it should be applied or when it would fit, and what would be the circumstances in which it would be warranted or not warranted.
Okay.
And be able to, similar to what you said, weigh pros and cons and determine on whether that fits appropriately or inappropriately.
Okay. So generally speaking, and the judge has already read you some instructions, they're consistent with what we've talked about. That's kind of the format you're going to get. You're going to get instructions of how to weigh things and determine things and ultimately make a decision. So is that kind of what you were talking about?
Yes, sir.
Okay, you weren't talking about anything specific with the death penalty or death penalty case.
I guess it would be this situation specifically.
Understanding how the rules work.
Yes, sir.
Okay. And what we talked about, are you comfortable following those rules? Assuming the judge is going to give you, and I'm confident she will, are you comfortable following those rules, what we discussed?
Yes, sir.
Okay. I have no further questions, Judge. Thank you.
All right. Either side need to approach?
No.
No, Your Honor.
All right, sir. We're going to ask you to come back one more time, last time. Unless you're seated on the jury, then you'll be here every day. But we don't know the date yet. You're now going to be a purple dot. When you're calling into the jury phone number, you're listening for instructions for the purple dots. I have no idea what day it will be, but I can tell you it won't be this week, so don't even start calling until Thursday, all right? We're giving you a package of information. In that package is included a jury sequestration package that provides you quite a bit of information about that sequestered juries need to know. The day you come back for final questioning, you have to have packed a bag enough for sequestration, because if you're picked for the jury, we sequester you that day. Leave it in your car. The deputies will help you come get it if you need it. If you don't, you'll just go home and unpack. All right? Do you have any questions?
No, ma'am.
All right, so everything's in there. Have a good afternoon. Thank you for your service. Do not look at anything, read anything, let anybody talk to you about this case. All right? You're free to go for today.
Thank you, ma'am.
All right, thank you.
I should leave this here, ma'am?
Yes, sir, please. Thank you. So that's the juror number 27 and seat number 25. All right, I need the juror in seat number 26, who is juror number 5. All right, sir. Good afternoon. I know it's been a long day. Did you have a good lunch?
Yes, I did. Thank you.
All right, sir. I need you to just be honest with us. Don't worry about what your answer is. There's no right or wrong answer to these questions, okay? Did anybody at lunch or after lunch, have you heard anything? Anybody talk to you, anything at all about this case?
No,
All right. And have you heard something about this case before this? You have not?
no.
Okay. So tell me what your position is on the death penalty, or what your beliefs are about the death penalty.
Oh, well, that's a very complex question.
Yes, it is.
And I'm man of faith. I believe in God. I don't go around judging people. I believe that people should be held accountable for their behavior. However, when it comes to the death penalty, I cannot say I believe or I don't believe, because of the fact that it all depends on the situation. People have to, obviously, as I mentioned before, be held accountable for their act based on the structure of the society, and there's rules that everybody have to follow, and based on that, sometimes we have to follow guidelines, and if we feel that this is the best approach based on the guidelines and which need to happen, I probably say, yes, I believe.
All right, sir. Jurors in these cases, if Mr. Loyd was convicted of first-degree murder, and only if, then there's a penalty phase, and that's when the death penalty becomes an issue in these cases. At that time, what you're required to do as a juror is you're going to have to listen to evidence from the state. They present aggravators, reasons they believe death would be the appropriate sentence. The defense presents mitigators, mitigation, reasons they believe life without parole is the appropriate sentence. I give you at the end of all this evidence, I give you the jury instructions, and you and your fellow jurors retire to the jury room to talk about this. You're going to weigh the aggravators and the mitigators and decide. You have to make an individual decision as to whether you believe life or death is appropriate, okay? If at the end of weighing all of that, you came to the decision that you believe the appropriate sentence in this case was life without the possibility of parole, could you vote for that?
After reviewing all the facts, and if this warrants that, I'd probably say yes.
Okay. And if after reviewing all of the evidence, the facts, everything that you've heard, weighing it all, you believed that the appropriate sentence was death, could you vote for that?
Well, never being in that situation, it's hard to say. I believe, again, that if for some reason that's the structure, this specific situation, after reviewing all the facts, warrant that step, I probably will say I'll probably support it.
Okay. Do you have any doubts about your ability to do that?
Well, it is very difficult for me to answer this question because in my line of business, I dealing with specific situation every single day. And I have learned the hard way that sometimes you have to step back and listen, understand the whole situation before you even have an opinion. Again, I've never been in this kind of situation. I'm just going to be very honest with you. It is very difficult. These are questions that for me, they're very difficult to answer because they're based on assumptions.
Okay.
What can I do? What can I not do? It's hard for me to say because, again, I have never been in this kind of situation before.
I understand that we're asking you to predict the future. Do you have any moral or religious objections to the death penalty?
I think that, again, if for some reason there's a structure in society that require or warrant after certain aspects that had happened and that warrant that decision, and I don't have any problem. I think that I probably support it if I feel that that's something that needs to be supported based on the facts.
As I told you, Mr. Loyd has raised the defense of insanity in this case, and I briefly read to you a little bit of the jury instruction on that. Could you listen with an open mind to any evidence that was presented as to the defense of insanity?
Well, I think that every single fact, they need to be here before. This is something that is very, very serious and critical. And I think that in order for you to make this kind of decision, you really, really have to be able to consider all the facts that there in this specific case.
Okay. Then last thing, you remember I told you that Mr. Loyd had been convicted of the murder of Sade Dixon and the unborn child, correct?
Correct.
All right. I'm now telling you that that information cannot be used by jurors to decide whether or not Mr. Loyd is guilty of this case. Do you understand that?
Yes.
Do you believe that you can follow that instruction?
Yes.
All right. Thank you, sir. I'm going to turn this over to the lawyers. Mr. Buxman, you may inquire.
Good afternoon, sir.
Good afternoon.
So it sounds like based on your questions that you just answered for the judge, certain cases you feel the death penalty could be appropriate, certain cases it may not be, right?
Correct.
Okay. Do you understand that in Florida, in order for a case to even be eligible for the death penalty, the state has to prove certain additional factors called aggravating factors, which make this case more egregious than maybe a typical first-degree murder case?
Yes.
Okay. There is no such thing in Florida as an automatic death penalty if someone's convicted of first-degree murder. Do you understand that?
Yes.
So no matter what evidence you hear about the first-degree murder, whether it was premeditated, there was no accident, there was no defense, that in and of itself does not mean that the death penalty is automatically appropriate. Does that make sense?
Yes.
What you would have to consider in determining the proper punishment, both the evidence that deal with the aggravating factors as well as mitigating factors. Mitigating factors are things that could cause the proper sentence to be life in prison as opposed to the death penalty. You'd have to consider all that before making your decision.
Yes.
Can you do that? Consider all the evidence before making your decision.
Well, I do that for a living.
I'm sorry?
I do that for a living.
You do that for a living. And what do you work at the Hyatt, I believe?
Yes. Yes.
What do you do on a daily basis at the Hyatt?
Well, I am the director of operation, and my job is obviously the planning, financials, customer service, accountability, and dealing with not only with customers' grievances, but also associates' grievances too as well. And through this process, I'm working side by side with HR to make decisions on next steps to take based on different situations that had happened in the hotel.
You got a lot of responsibilities, it sounds like.
Yes,
Okay. The aggravating factors that we've been talking about, the thing, death penalty, an appropriate sentence in this case, those are confined and limited in number by statute. You only can consider those aggravating factors the judge tells you you can consider. Can you confine your focus just to those things the judge tells you you can consider?
yes,
Mitigating factors are a little broader. Are you able to, you probably have already answered this, but let me just make sure. Are you able to consider all of the evidence that relates to mitigating factors before you make a decision as far as the proper punishment, what the proper punishment should be in this case?
yes,
Okay, and now this is not the time for us to talk about the evidence that deals with the different aggravating factors or mitigating circumstances, what goes into each of them in this case. This isn't the time for that. So even at first blush, if you hear something is presented to you as a mitigating circumstance, and at first blush, you may think, not sure if that's really important. Can you agree to hold off your decision on whether it's important until you hear all the evidence?
yes,
So if I were to stand up here and rattle off 100 different mitigating
Overrule. Go ahead.
if I were to stand up here and talk about 100 different mitigating circumstances, would your answer be the same that you're telling me you would consider each and every one of those before making a decision?
yes,
Now, once you hear all the evidence, you can decide whether has that aggravating factor or mitigating factor been proven. If it has been proven, you can say, I want to give that a little weight, it's not very important to my decision. Or you can say, oh, that's very important, I'm going to give it more weight. But the focus is, you need to hold off on making that decision until you hear all the evidence. Make sense?
Yes.
Do you think Mr. Loyd here deserves a jury who will consider all that evidence before making a decision?
yes,
Once you hear all the evidence, you'll be asked to then do a weighing process to determine and to analyze the aggravating factors in relation to the mitigating factors and determine whether one outweighs the other, which will then lead into your decision of what the proper punishment should be in this case. The decision, if the jury votes that, if one person on the jury votes that life, then that becomes the sentence in this case. So that decision as far as what the proper punishment is an individual decision for each of the jurors to make. You understand that?
yes,
In order for the death penalty to be a punishment in this case, all 12 jurors would have to unanimously agree that that is the proper. Okay, do you understand?
yes,
Obviously, if the decision has to be unanimous and the jury comes back and makes that decision and says the proper punishment in this case is death, everyone would know that you voted for it, right?
correct,
Would you be able to walk into this courtroom and raise your hand and say, Judge, in this case, I believe the death penalty is appropriate and that this man deserves to die for what he did?
Overrule.
Now, that's one way to ask that question if you're with a bunch of friends and outside of a courtroom just talking. It's a different analysis if you actually find yourself in that situation being the one to make that decision. Do you think you could make that decision if you felt the evidence supported it and you felt that was the right decision?
I probably will, but I have to be 100% sure.
Okay. If you were 100% sure in your mind that that was the right thing to do, you could do it. Is that what you're telling me?
Yes,
Okay. Another issue in this case, like the judge indicated, is the issue of insanity, which involves mental illness. Do you or a close friend or a family member, have any of you dealt with a mental illness in the family?
no,
Do you feel that mental illness is a kind of a, some people think, oh, mental illness, that's bogus. What do you think?
I think that people could use that sometimes as a tool to not take responsibility for their behavior, and some other situation is fact in life.
Okay. Will you be able to hold off judgment until you hear all the evidence on the case to determine whether insanity is a viable defense in this case?
Yes.
Okay. Thank you, sir. No further questions, Your Honor.
Take it. Mr. Lemon, you ready for it?
How are you, sir?
I'm doing well, thank you.
I didn't hear the whole job that you had. You said you worked at a hotel,
Correct.
and what do you do?
I'm the director of operations.
Okay. So you're responsible for a lot of people and a lot of things.
Yes.
Okay. Now, if I was to use a scale, and we were talking about where you think you fall on the issue of the death penalty, and 1 would be never voting for death, and 10 would be always voting for death, where do you think you would place yourself on that scale?
I will tell you probably right in the middle.
Right in the middle, like a 5.
Yes.
Okay, and why do you say that?
Because some people deserve not to go through that process, some others might not. I don't think anybody deserves to go through that. But however, there's, again, certain circumstances and structures set up in society that require certain steps to follow, and that person's behavior warrant to do something, to go through this process, I think that I probably would go and support something like that.
Okay, so you can follow the law.
Correct.
Okay. Now I want to talk to you about a little bit about the law, okay? So the way it works is that in order for you to consider the death penalty, Mr. Loyd would have to be convicted. So to get to the second part, it's like a second trial, Mr. Loyd would have to be convicted first of first-degree murder. Do you understand that?
Yes.
Okay. And then you would be given instructions, which the judge read parts of some so far, but you would be given more elaborate instructions on what the rules are that you have to follow, okay? So the first rule is that the entire jury has to find that at least one aggravating circumstance, and those are the things the prosecutor talked about that would enhance Mr. Loyd's sentence. At least one of those have to be proven beyond a reasonable doubt by the entire jury. Okay, you following?
Yes.
Okay. That's the only thing the entire jury has to decide. Everything else is individual. It's your independent decision on every other piece of decision-making that you have to make in regards to the death penalty, okay?
Okay.
Okay, and it's obviously a serious situation, as you already voiced, okay? So after that finding of the one aggravator, the next decision you would have to make is you would have to look at the aggravators, whether there's one or more than one, that the state presented to you, and you individually would have to decide which one they proved beyond a reasonable doubt. And once you decide of that aggravator being proved beyond a reasonable doubt, then you would have to assign a weight to it. You can assign little weight, some weight, a lot of weight. It's all up to you individually. You understand?
Yes.
So the next thing then is you would have to look at the mitigation that I present to you. And it could be a dozen things. It could be more or less, but each one of those mitigating circumstances that you are provided, you have to decide whether they are proven. And the standard for proving those is less than beyond a reasonable doubt. It's a lower standard. So you would have to look at each one individually and decide which one were proven or all of them proven. That's all up to you individually. You following?
Yes.
Okay. Then you have to take the mitigating factors and you have to assign each one weight. You may find some more weighty, some less weighty, some a little bit of weight, medium weight, great weight. It's all up to you. It's all your decision. Once you do that, you have the mitigation. And in your mind, you have to look at then the aggravating factors and the mitigating factors, and you have to assign weight to the whole part, the aggravators and the mitigators. And then once you do that, you have to decide whether the aggravation outweighs the mitigation or whether the mitigation outweighs the aggravation. Okay? If you find the mitigators outweigh the aggravators, it's always a sentence of life. There's nothing but a sentence of life. You're done with your job, it's over. Okay? If you find the aggravators outweigh the mitigators, then you go to the next step. And the next step is deciding whether you believe Mr. Loyd should receive a death sentence. The law says, without question, and you'll hear this from the judge, you are never required to vote for death, period, ever. That's up to you individual, and if you want to decide not to vote for death for whatever reason, maybe it was something you heard in the trial, maybe it's something in your heart that you feel, some mercy, whatever it is, you never have to vote for death, even though the aggravators outweigh the mitigators. You understand that?
Yes.
It's still an individual decision. The decision is vote for death or not vote for death. That's yours, okay? Collectively, in order to have a death sentence in Florida, each individual decision of all 12 jurors has to be voting for death. If one of the jurors vote for life and the other 11 vote for death, it's considered a life verdict. And Mr. Loyd would be sentenced to life. Do you understand that?
Yes.
Okay. Now, a couple of things I want to talk to you before we wrap this up. Number one, do you feel like you're the type of person that if you made your mind up about something, that you're going to stick to your beliefs?
Well, I think that no, because if I only can make my mind up when I have all the facts together.
And I'm not asking you to make your mind up today. I'm talking about you sitting back in the jury room. You have been given all the facts you're going to be given, and you making a decision, one way or the other. Once you make that decision, are you going to stick by it?
It can change.
Okay. And what kind of things would change it?
New facts.
There is no new facts, okay? You can be certainly talking to other jurors about their opinion. There's nothing prohibiting you communicating with other jurors about what their decision is, what they believe, what you believe. But at the end of the day, you have to make the decision yourself. You understand that?
Yes.
Once you made that decision, hearing from other people, listening to other people, respecting other people, would you stick with your decision?
Yes.
Okay. So that's the next thing I want to talk about. Do you think it's important to respect other jurors' decisions?
Absolutely.
And why is that?
Everybody have a different opinion.
Okay.
It had to be respected based on different perspectives.
Okay. And would you agree that as a juror in this case, you would respect any other juror's opinion, whether it's life or death, you're going to respect it?
Absolutely.
Okay. And would you, if you saw another juror trying to bully a juror about their opinion, would you voice your concern about that?
Absolutely.
Okay. If I can have a second, Judge. One more quick area, sir. Now, the judge told you absolutely, unconditionally, you're not allowed to use the knowledge that you have in the first part of the trial about Mr. Loyd's prior conviction for murder. You remember her telling you that?
Yes.
Okay. There are times when even a juror is told that they are unable to do that. Are you able to follow the judge's instruction?
Yes.
Okay, thank you, sir. I have nothing further, Judge.
Either party wish to approach?
No.
All right, thank you. This is juror number 5, seat 26. Sir, we're going to have to ask you to come back one more time for the final jury selection process. You're now a purple dot. We're going to give you a purple dot for your badge. So when you're calling in to the jury room to find out when you're supposed to come back, you're listening for instructions to the purple dots. We're also giving you a jury sequestration package. It explains to you what it's like to be a juror that's being sequestered and what you need to bring, and et cetera. When you come back for that last day of questions, you need to have packed the night before. Leave your suitcase in the car. If you're not picked as a juror, obviously you're just going home, but if you are picked as a juror, we sequester you right then and there. So the deputies will go with you to your vehicle to get your belongings to take you to the hotel. And the phone number that you call is in the packet. Do not call before Thursday. We're not going to need you before next week at the earliest, so just start calling Thursday. Listen for instructions for purple dots. Any questions?
No, no questions.
All right, thank you so much, sir. You have a good afternoon.
Thank you.
You're free to go. All right, I need the juror in seat 27, please. And this is juror number 334. The juror in seat 25 is on the panel, right? On the final panel. Juror in seat 25 went through to the final panel, right? Yeah, okay. Good afternoon, ma'am. How are you?
I'm fine,
All right, welcome back.
thank you.
We just have a few more questions for you. Let me start, and again, ma'am, the important thing is for you to tell us the truth. Don't worry about whether it's right. There's no right or wrong answer to these questions, okay? You said you'd heard something about this case. Can you tell me what it is you've heard?
Well, I heard it all over the news a couple of years ago.
Okay. How much of that did you listen to?
I listened to quite a bit of it because I watch the news every morning when I'm getting ready for work.
Okay. Do you watch the same channel all the time or different channels?
Pretty much the same channel all the time.
And which one is that?
Channel 2.
Okay. Based on what you heard, did you form any opinion as to whether or not Mr. Loyd is guilty?
Yes.
Okay, what's that opinion?
From what I heard on the news, it sounded like he was guilty.
All right. Is this something that you talked about with friends or family when it was all on the news?
When it was all on the news, yes.
Okay. And did they agree with your assessment at that time that you felt like he was guilty?
Yes.
To sit as a juror in this trial and be fair to both sides, but to be fair to Mr. Loyd, you have to presume he's innocent. Okay? You got to put everything you heard aside, and your verdict has to be based solely on what's heard in the courtroom. But you have to start by presuming he's innocent. Do you think you can do that?
I think so.
Okay, why?
Because you said something today that had me thinking about it while I was at lunch, and that was the defense position of insanity, and that was not something that I had thought about before, and it intrigued me. And I remembered from a while back, growing up, my dad always told me there's 3 sides to every story, your side, his side, and what really happened. So I've only heard one side of what was on the news, and I would like to hear the other side.
Okay. So when you're sitting there as a juror, describe for me what you're thinking, which is it, I think this man's innocent. I'm waiting to see if the state can prove this beyond a reasonable doubt. I think this man's probably guilty, but I'm willing to listen to see if I'm wrong. Or I think he's guilty and I think he should prove to me that he was either insane or he's not guilty. Or something else.
Your second comment, that he's probably guilty, but I would still like to see if I'm wrong about that.
Okay. State?
No objection.
Feds? Okay, ma'am. I appreciate your service. I appreciate your willingness to serve more than you can possibly imagine. But I don't think this is the case for you. You're free to go, and the mask is a gift, a second gift to you, along with the first one. All right.
Okay.
Thank you so much. Have a
Thank
good.
you.
You're discharged as a juror in this case.
Okay.
Juror in seat 28. This is going to finish this group. So what I'm going to do for the next two groups, 130 and 3, is I'm going to bring them both in at the same time, instruct them both at the same time, find out who has formed opinions, and we're going to do it that way. Since I have two groups waiting and it's 4 o'clock. Let's get 28 in here. This is juror number 220, seat 28, panel 1. Good afternoon.
Good afternoon.
I bet you thought you were never going to get in here. Well, of these two groups, I have 2 more groups waiting. If it makes you feel any better. All right. You've never heard anything about this case, is that correct?
No, ma'am.
All right. Tell me what your beliefs or position is on the death penalty.
I've never really thought about it.
Okay.
Never had to make a choice of if somebody's going to die or not. So my views on it is, depending on what is presented, is what I would answer to.
All right. In these cases, let's say Mr. Loyd was actually convicted of first-degree murder. That's the only time you have to make the decision about a life sentence or a death sentence. So the guilt phase is over, and now you're in the penalty phase. State's going to present evidence of what are called aggravators, legal reasons why he should be sentenced to death, they believe. Defense presents mitigation, reasons they believe that he should be sentenced to life without parole. You have to listen to all of it with an open mind until the end. Then you go into the jury room, and you and your fellow jurors can talk about it as much as you want. You have to weigh the aggravators, weigh the mitigators. I give you jury instructions about all of this. But in the end, it's your individual vote, and you have to decide, after weighing all this, life without possibility of parole or death. So if at the end of that, you believed that the appropriate sentence was life without the possibility of parole, could you vote for that?
Could, yes.
And if at the end of that process you believed that the appropriate sentence was death, could you vote for that?
More than likely, yes.
Okay. Do you have any hesitation about that?
No.
Mr. Loyd has raised the defense of insanity, not guilty by reason of insanity. I read you a brief blurb about the instructions for that. You have to be able to listen to that defense with an open mind. You can't start out thinking, this is nonsense, I'm never going to accept this. You have to listen with an open mind, and if the evidence leads you that way, accept the defense. Is that something that you can do?
Absolutely.
You also heard me say that Mr. Loyd's been convicted of the murder of Sade Dixon and her unborn child, and that he was sentenced to life on that. You remember when I read that to you?
I do.
Right. I'm now instructing you that that information cannot be used by you to determine whether or not Mr. Loyd is guilty of these charges. Do you understand that?
Completely.
Do you believe you can follow that instruction?
Without a doubt.
I mean, later on in the case, I will explain to you what that information can be used for, but it cannot be used to determine guilt.
Okay.
Thank you, sir. State, you may inquire.
Oh, still, okay.
Not yet.
I
Good
know.
afternoon, sir.
Good afternoon.
So it sounds like you're relatively neutral as far as the death penalty. It could be appropriate in some cases, it may not be appropriate in others.
Yes.
All right. Now, in order for the death penalty is not an appropriate sentence for every single type of first-degree murder. You understand that?
Yes.
The legislature has determined that in order for the murder to be eligible for the death penalty, the state has to prove certain aggravating factors that make this murder more egregious than a typical first-degree murder.
Okay.
Sustained as to that. I'm going to rephrase that.
Yes, ma'am. The state has to prove certain aggravating circumstances to set this murder apart from other murders.
Okay.
Okay? And only if that is done does the case become eligible for the death penalty.
Okay.
In Florida, there is no such thing as a murder qualifying for an automatic death sentence. Do you understand that?
Yes.
So no matter what evidence is shown of the first-degree murder, it was premeditated, there was no accident, there was no defense, those kind of things, there still has to be evidence shown of aggravating factors. And you'd have to consider the aggravating factors along with mitigating evidence and factors to determine what the proper punishment should be.
Okay.
Can you follow the law that says you have to focus on all this evidence before you make a decision, and the death penalty is never automatic? You follow that law.
Yes.
Aggravating factors are confined to certain things that are in the statute, and the judge will tell you which aggravating factors are appropriate if we get to that point in this trial. Can you agree to confine your focus just on those aggravating factors the judge tells you are relevant to this case?
Yes.
You will also hear, if we get to that point, evidence of mitigating factors. Can you agree to listen to, this is not the time for us to talk about the details and the specific evidence that relate to aggravating and mitigating factors in this case. That'll happen later. Can you agree to listen to all of the evidence dealing with mitigating factors and consider it before you make an ultimate decision of what the proper punishment should be?
Yes.
Do you think Mr. Loyd deserves to have a jury that will remain open-minded and listen to all evidence presented to it about mitigating factors before making a decision?
Absolutely.
Okay. If I were to stand here and mention 100 different aggravating factors, would your answer always be the same of I would consider it and evaluate it before making my ultimate decision?
Yes, 100%.
Now, once you hear the evidence and evaluate the evidence as it relates to aggravating factors and mitigating circumstances, then you can decide it hasn't been proven. The evidence hasn't proven that factor. If you find it's proven, you can say, I don't think that is very important or very weighty in my decision. Or you can say, that's a really important piece of evidence and very weighty in my decision of what the proper punishment should be.
Yeah.
As long as can you assure, though, that you will listen to all the evidence before you reach that decision?
Of course.
All right. The judge, I believe, told you that the decision as far as what the proper punishment is in this case is an individual decision made by each individual juror.
Yes.
If one of the 12 of you decide life is the proper punishment, that becomes the sentence. Does that make sense?
Yes, sir.
If all 12 of you determined that the death penalty was the proper punishment, only then does that become a punishment in this case.
Completely understand.
Obviously, if it has to be unanimous, and that's what happens, and the jury comes back and it's a unanimous decision for the death penalty, everyone would know you'd vote, right?
Correct.
Knowing that, would you have any concern or any hesitation coming into this courtroom, raising your hand and saying, Judge, this man deserves to die, if you believe the evidence supported that sentence?
Yes.
Judge Marquez also mentioned the insanity defense, and that is involving mental illness. Do you, a close friend or a family member, have any involvement with mental illnesses?
Not personally, but family members work in the facilities, yes.
Okay. So I gather by that statement that some people think mental illness isn't really real. You believe mental illness is a real issue in
It can
certain
be
people.
treated, yes.
Would you be able to listen to all the evidence about the circumstances surrounding a mental illness to determine if it exists and what the
Absolutely.
ramifications are of that before you make a decision whether insanity is a defense in this case?
Absolutely.
All right. Thank you, sir. No further questions, Your Honor.
Thank you, Mr. Buxton. Mr. Wenneman, you may inquire.
Oh, one more. Afternoon, sir. How are you?
You, sir.
So when you first heard the judge reading the fact that Mr. Loyd was convicted of the murder of Miss Dixon and her unborn child, what were your thoughts?
Really no thoughts on it. This is different. Whatever the case is here is different from what happened in the past. Can't live in the past.
So you're saying you had no feelings one way or another?
Not in a sense of guilt or not guilty of whatever this is.
Have you ever served on a jury before?
Never.
Did you know when you heard that, well, I'm not going to be able ever to consider that in the first part of the case?
No.
So when was it that you decided it wasn't important?
Well, I hate to go into some of my history, but I was like a grievance man. So everybody had their grievance. You had to hear what the grievance was about before you can make a determination. That's the same thing with this gentleman here. What he did in his past is his past. What he did here, I don't know. We'll have to figure that out.
So you said part of your grievance evaluation? I didn't understand.
Yeah, I belong to you, and I was a grievance man.
Okay, okay. And what union was that?
Steelworkers,
Was that up north or down here?
Pennsylvania.
Okay. And you came here to retire or?
Nope, work at Universal Studios.
Okay, okay. So, and then you heard the judge instruct you on the fact that you can't use it, but when you heard that, did you think that Mr. Loyd was 90% guilty and 10% innocent, or what did you think?
I keep telling you, I didn't think anything of that. That was his past, whatever this.
Okay. And so, do you feel comfortable enough to follow the judge's instructions on that issue?
No.
So you do feel comfortable enough to follow the judge's instructions?
Yes.
Okay. And you're saying 100% you're not going to let that factor into your decision?
No.
Okay. Now, Mr. Bruxman said, you know, there's no automatic death penalty in Florida, which I don't disagree with him. But there are some people who have really strong feelings about certain types of killings. So I want you to think in your mind of one, if there is one, that you strongly feel about, and whether you would consider not just automatically deciding to vote for death because you have such a strong feeling about that, you wouldn't be able to consider anything else.
No. Like I said, I don't know what he's actually done in this case. That would determine how I would feel.
Well, you heard he killed a police officer, right?
Yeah.
Okay. And you have some police officers in your
Family
family?
passed away.
Who are they?
There's a brother,
Okay. What department did he work for?
narcotics.
I'm sorry, I didn't hear that.
Narcotics?
No, where did he work as a police officer?
Oh, Western Pennsylvania?
Okay. And was his death related to anything to do with his service?
No.
Is he the only one that's in your family that's in law enforcement?
I have a brother-in-law, but I met him like twice.
Okay.
Don't really know him.
And was your brother a lifelong police officer?
No, he was in the military and then he went to become a police officer for
Okay.
our local city.
Did you ever have any interaction with the people you worked with?
Who? What?
Your brother, did you ever have any interaction with other law enforcement
Oh,
officers?
yeah, absolutely. Small town,
Okay, so you grew up in a small town where everyone knew everyone.
pretty much.
Okay. So what are your feelings about this case involving the death of a police officer and the fact that you have a deceased brother who was a law enforcement officer?
It's not going to have any factor because I know good police officers and I know bad police officers.
Okay. So that's not going to affect you at all?
No,
Okay. Now, what do you think about, that Mr. Loyd's doing life without the possibility of parole, based on what the judge read you, right? Mm-hmm. What do you think of that as a sentence as opposed to the death penalty?
again, I think it would depend on the evidence that is presented and what the factors were here. I don't know.
Do you think that life without the possibility of parole, generally, in comparison to the death penalty, is a lenient sentence?
No, because you're in prison. I mean, for the rest of your life. I mean, you have no life.
Okay. Now, you said you didn't give it much thought about the death penalty before you came in here.
Mm-hmm.
Is that right?
Yeah.
But certainly you heard on Friday this was a death penalty case, so you had over the weekend to think about it.
Mm-hmm.
And obviously today, while you were waiting,
Mm-hmm.
do you have any other thoughts about the death penalty?
As of now, like I keep saying, I would have to hear what's being presented. Do I have any issue sentencing him to death? That's why you would have a panel.
Okay, and I understand that you'd have to hear more, but that's not my question I'm asking.
Okay, I apologize.
I'm
not completely
asking
understand.
you personally,
Yes.
do you have an opinion about the death penalty
No.
at all?
No. If it's just, and that's what we decided, yeah, he would have to die.
You said it's justice, is that what you said?
If everything is presented, and we as a group decided the death penalty was what we were looking for, and we all agreed on that, I would probably follow suit.
Okay. So you would consider yourself like a follower of others?
No, more of a leader.
I'm sorry?
I would say as more of a leader.
Okay. Well, as a leader, I'm still not getting what you're telling me about your thoughts and opinions of the death penalty. Not the system, not the way it works, your thoughts and opinions, i.e., I don't like the death penalty, I do like the death penalty. Over the weekend, I thought about it. It's a great responsibility. It's not a responsibility. What are your thoughts? That's what I'm really trying to understand.
I'll be honest with you, I don't really know yet. I don't know in my mind if I would sentence a person to death unless there was enough evidence showing me that that person deserved it. In my mind, not in their minds, my mind.
Okay.
So yes, I probably would say I would give you the death penalty.
So you're leaning towards the death penalty?
No. I want to see the evidence first. I would want to see what was.
But you said a moment ago, I probably would say I'd give you the death penalty. What do you mean by that?
Well, if the evidence showed that, in my mind, that this person deserved the death penalty, everybody has certain morals in life. And if you cross my morals like any other person, yes, I would probably say yes to that.
Okay. So what's important to you is your own individual morals.
Somewhat.
Okay. And you believe that if that person that you're judging, whoever it is, crosses your own personal morals, you'd probably give them the death penalty.
Somewhat, yep. If
Okay.
you would harm my father or somebody like that close to me, yeah, death penalty would definitely be what I would want.
Okay. So, and I understand your father or your brother or someone close to you, but what about other people who cross your morals? They do something despicable in your mind. Would you give them the death penalty?
I'd have to see what that was all about.
Okay. How much of your morals would play into the decision to give a person the death penalty?
I mean, I've never had to come to that kind of.
I understand, but could you put a number on it? Could you say, all the time, anytime, 20%, 30%, 50%?
I really can't answer that, sir.
Okay.
I mean, there's no way of answering that without knowing what you're asking.
Well, I guess I'm asking, and I think I've asked, and I think you answered it on some level. I'm just trying to,
Comprehend it. Would I put somebody to death if I felt they deserved it? Probably.
Okay. But that would be based in part on your own moral thinking.
Yeah.
Okay. I want to talk a little bit about the death penalty. I know the prosecutor talked about it some. We're going to go through this real quickly. Okay? So essentially in Florida, there's an instruction, jury instruction, the law, the judge will read to you. It's separate from what the law is on the first part of the case. The only way you get to this part of the case is if he's convicted, and then you have to make a decision, okay? So what happens is the prosecutor puts on evidence of aggravating factors. You heard that word before. He described it for you. We put on mitigating factors. They could be, a dozen, could be 10, could be 5, could be 50, okay? And so the first thing you have to do as a juror is that you have to decide as a group, this is the only time you're doing something as a group, that one aggravating factor was proven beyond a reasonable doubt, okay? All of you have to decide that. Doesn't matter what the aggravating factor is, but one aggravating factor was proven beyond a reasonable doubt. Collectively, you decide that, okay? Everything else follows is you individually. The next thing you have to do individually, because this is an individual process, the jury instructions say without question, it's an individual decision on these issues, including whether you vote for life or death. The next thing is you have to decide what aggravators the prosecutor has proven beyond a reasonable doubt. And those aggravators have to be, could be 1, could be 2, could be 3, could be many, okay? Once you decide that, then you would go down to the mitigation, whatever the mitigation is. The mitigation has to be proven to a lesser standard than beyond a reasonable doubt. And you would have to decide whether one or more of those mitigating factors have been proven. With the aggravating factors, you're going to give it some weight, whatever weight you think should be entitled to. It could be a great amount, a little bit, so forth and so on. On the mitigators, you're giving that weight too. So basically, you have 2 balls, and you decide which one is heavier. If you find the mitigation is heavier, then you have to vote for life. There's no question what you have to do. If you find the aggravators outweigh the mitigators, then you may vote for death, but you're never compelled to vote for death. The law says you never have to vote for death if you don't want to, okay? After you make that decision, the final decision you make is whether you're going to vote for the death penalty. Again, an individual decision. Collectively, if one or more of the jurors say life, it's a life verdict. Collectively, if all 12 say death, it's a death verdict. You follow me?
Absolutely.
Okay. So the next issue is you as an individual, when you're in this process, making a decision, weighing, that's an individual thing. No one can tell you whether to talk to other jurors or not. That's completely up to you. You can talk to jurors, you cannot talk to jurors, but the final decision is yours. Once you make that decision, do you think you are the type of person that will stick by your guns?
Yep.
Okay. So now the next question is respecting other jurors. Do you have any problem with respecting the person sitting to the left and right of you in their decision, no matter what it is?
Nope.
Okay, you're never going to try to bully them.
Nope.
And if someone's bullying them, are you going to speak up?
Yep.
Okay.
Sorry about yep. Yes.
There's also something called victim impact, okay? So the judge is going to read you along with the other instructions, if we get to the penalty phase, that the jury gets to consider the uniqueness of the victim. And there will be testimony, and there may be pictures about the victim. You get to consider all that, because obviously in our community, we all think that's very important. But the one thing about that is you cannot consider that information in deciding whether to vote for death or not. It's not an aggravating factor, okay? Can you follow that rule?
Yes.
Okay. One second, Judge. Okay, what? Oh, sorry. Those are all the questions, Judge. I would like to come sidebar.
He's going through, Teresa. All right, sir. It's been a long day for you. We're going to ask you to come back one last time for jury selection, for final jury selection. You're now a purple dot. Yeah, we're going to need your badge to put the purple dot on it. We're going to give you a package. That package includes instructions for jurors if they're sequestered. I don't know what date we're calling you back because I don't know when we're going to get to jury selection. It won't be before next week, so you don't even need to start calling until Thursday, all right? But just call the number every day. When you hear purple dots report on such and such a date, that's you. You need to pack your bag for that day because if you are chosen as a juror, you will be sequestered on that day. So, and the deputies will go with you to your car to get your suitcase. Just leave it in the car. It's just there in case you're picked for the final jury. The number and everything you need to call is in that packet. Any questions?
You said a week or this Thursday?
Start calling the number to find out when you're supposed to come in on Thursday. We will not need you before next week at the earliest. So you just go on about your life, except avoid the news, the newspaper, and anybody who wants to talk to you about all this. All right? Thank you so much, sir. You're free to go today. All right, that's it for this group. As I said, we're going to put the other two groups together. So, Nan. All right, actually, State, you're going to need to flip around, because I can't, are you going to put 20 in the jury box, or are you going to put them? All right, never mind. Let's put them in. Let's bring them in. Paddles corresponding to their seats. This is still panel 1. All right, there are some that are coming off panel 2 on this. All right, folks, we're going to need to swear you in one more time, so if you'll stand, raise your right hands, please. Face the clerk. Stand up, raise your right hands. Thanks. All right, have a seat, please. All right, ladies and gentlemen, I apologize for the delay. This has gone much slower than we anticipated. I'm aware of how late it is. We're going to try and move you through here as quickly as possible, but I don't want to have to make you come back tomorrow. So I'm going to try and get through this tonight. If you have any kind of issues, I know during seat 31, you have a child care issue. I'm aware of that, and we'll get you out of here in time. If you have any kind of issues, let the deputies know, and they'll help you with those. All right, you're here for individual juries questioning. This is phase 2 of this. As I informed you, this is a capital case. It's a death penalty case, and we question jurors in groups in these cases. So I've got a few instructions for you and explanations for you, so you're aware of what it is we're doing and you understand the process a little bit better, and I'm going to inform you a little bit more about the case. Let me start by telling you that in this case, Mr. Loyd is charged by indictment. And I have the indictment here in my hand. It's a piece of paper, folks, all right, that we use in the state of Florida to tell people what they're charged with. You have to tell people what you're accusing them of doing. This is how we do it. The fact that there's an indictment you cannot consider that to be evidence of guilt. That's not how this works at all right? So he's been charged with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. This case is tried in 2 phases. The first phase is the guilt phase. The guilt phase is conducted pretty much the same way as we do all criminal cases. You're going to listen to evidence, testimony, physical evidence, all of that. You're going to listen to everything that's presented in the courtroom, and then you will be asked to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all of the counts, meaning that each juror must agree on each count either to acquit or convict. But the only count that qualifies for the death penalty is count 1, the murder, the first-degree murder, all right? If and only if Mr. Loyd is convicted of first-degree murder do we move into phase 2. But sticking with the guilt phase, the burden of proof for the government is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you are deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not guilty on the charges, including murder 1, on its own merits. And you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense or not guilty. And we expect you, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, you will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment, without the possibility of parole, should be returned. If that happens, a special set of rules and instructions come into play. And I'm just going to give you an overview of all of this now. There are only two possible penalties for the crime of first-degree murder. Life without the possibility of parole is the automatic penalty for it, or in some cases, death. Those are the two choices in a capital case. All potential death penalty cases are divided into two parts. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones that the prosecutor may rely upon are called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute. The ones that the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt. A mitigating circumstances only needs to be proven by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters that are relevant to the defendant's background or character or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without parole. The state of Florida does not have parole. If you're sentenced to life in prison without parole, you die in prison. Before you may vote, the court impose a sentence of death, the state must prove beyond a reasonable doubt that one or more of the aggravating factors they alleged exist. The process of weighing the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weights or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. This is just a broad outline of the penalty phase, folks. The specific instructions are given to you if you're seated on the jury and if we get to a penalty phase. Let me say this too. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We just have to be ready in case we get to a penalty phase. We're going to be asking you some questions about the death penalty. In general, there's some questions that you're pretty much going to get asked, so I'm going to tell you what they are now so you can start thinking about them. You're going to be asked whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in a case. You're going to be asked if you have the same types of feelings about the death penalty. We are going to ask you about your feelings about the death penalty and whether you're in favor of the death penalty. You're going to be asked whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You will be asked whether you would agree to weigh the aggravating and mitigating circumstances with an open mind and determine whether or not life or death is the appropriate sentence. You will also be asked if you are a person who is so opposed to the death penalty that you simply would not consider it as a punishment in any case. Many people have strong feelings about the death penalty, both for it and against it. The fact that you have such feelings does not disqualify you to serve as a juror so long as you're able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. Additionally, Mr. Loyd has raised in this case the defense of not guilty by reason of insanity. There's a specific insanity instruction that will be read to you if you're on the jury, but I'm just going to give you an overview of what it is. The burden is on the defense. It's the only time the burden is on the defense to prove by clear and convincing evidence that Mr. Loyd had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. So we're going to be asking you questions about your ability to listen to that defense with an open mind. I have a statement about the case to read to you all. This is just a small blurb about the case, all right? On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That portion that I just read to you about the prior conviction cannot be used by you to determine guilt in this case. It is being told to you and used in the trial for a different reason, which the court would instruct you on later, all right? So, having given you these preliminary instructions and facts, how many of you have previously heard about this case? Just raise your paddles for me, please. All right, 31, 38, 39, 42, 46, 49, 50, 52. There's no way I have, oh, you're from the second panel, sorry, 57. All right, and from panel number 2, I have 1, 2, 4, is that a 4? 4, 6, 10, 14, and 15. For those of you who have heard about the case, how many of you have formed an opinion as to Mr. Loyd's guilt or innocence? Don't tell me what it is, just raise your paddles if you've formed an opinion. 31, 39, 42, 46, 49, 50, and from panel 2, 1, 2, 4, and 15. All right, folks, thank you very much. I'm going to send you all back into, are they going back in the jury room or the? Okay. Juror number 31, you please stay in the courtroom for me. The rest of you follow directions of the deputies. I'll be with you just as fast as I can, folks. All right. Can you move towards the middle there, please? Thanks, so we can all see you. All right, sir, your juror number 31 is in, you were in seat 31 and your jury number is 358, is that correct?
Yes.
All right, I need you to answer the questions truthfully. Doesn't matter what your answer is because there's no right or wrong. We're not grading you on this. We just need to know what's going on.
Okay.
How much information do you have about this case? How much have you heard?
I heard about it when it first happened.
Okay,
I remember because I worked in that area, so I was making sure that everything was safe around me.
okay.
Haven't really heard much about it recently.
Did you watch a lot of the news coverage when it first happened?
The day of, yes. I don't really like to watch a lot of news. So
Could
after
you-
that, I just kind of let it go.
Okay, could you actually see police officers and everything from where you work? Could you see what was going on?
No,
No?
no,
Could you hear any of it?
no. I was just around that area. I work
Okay.
in all different areas throughout the city, so.
All right, so after that day, have you heard a lot about it or read stuff about it?
Once or twice here and there, but not a lot.
Have you heard people talking about it, or if you know, coworkers, friends, family?
Yes,
And have you participated in those discussions?
somewhat, a little bit.
All right. Did you form an opinion as to whether or not Mr. Loyd is guilty?
I did.
And what's that opinion?
I believe he is.
Okay. Jurors have to be able to sit in these cases with an open mind, and they have to believe that they have to presume Mr. Loyd is innocent at the beginning of the trial until and if the state proves he's guilty beyond a reasonable doubt. Do you think you could put aside your belief he's guilty and do that?
Don't believe so.
Okay. State?
No objection.
Defense? No objection. All right, sir, I appreciate your candor. You are free to go. You're discharged as a juror in this case. Thank you.
Do I go downstairs to the lobby room or?
You're done.
Okay, thank you.
Thank you. You can keep the mask. That's a
Oh,
present.
thank you.
Not the placard there. All right. Juror in seat number 39, please. This is still panel 1, juror 184. Good afternoon.
Good afternoon.
You're the school principal, correct? All right, your juror number is 184? All right. Sir, you indicated that you've heard something about this case. What
Yes,
have you
ma'am.
heard? Just tell me what you've heard.
I just remember when it happened, all the news publicity.
Did you follow it?
Yes.
Did you watch it every night, every once in a while?
Am I okay?
Yeah, it depends on where you hold it, whether it echoes or not, yeah.
I haven't continued on.
All right. When's the last time you heard or read anything about the case prior to coming to jury duty? Okay, yeah, it was 2017. Have you talked about the case with family, friends, coworkers, anything like that? I'm talking about ever, not just now. All right. And as a result of all of that, did you form an opinion as to whether or not Mr. Loyd was guilty?
Yes,
And what's that opinion?
guilty.
All right. Jurors are required to presume that Mr. Loyd is innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe that you could put aside your feeling that he was guilty and follow that, or would you still be thinking he was guilty?
I would have a very difficult.
All right. Thank you, sir. State?
No objection, Your Honor.
Defense? All right, thank you, sir. We appreciate your service. I don't think this is the case for you. You are excused from this jury.
Thank you.
Need the juror in seat 42, juror number 224, panel 1.
I'm sorry, Judge, you said
4-2. Good afternoon, sir. How are you?
Doing okay.
All right, sir, you indicated that you've heard about this case.
Yes.
Can you tell me what you've heard?
It's mainly what was on the news, right?
Okay.
That he shot and killed his girlfriend or wife, whatever, and that kind of thing from the other case.
You got to keep the mic near you. Yeah.
Sorry.
I talk with my hands, so I sympathize. So, yeah.
Was at the Walmart, shot the deputy, ran, and then I remember the video of him getting arrested and then being kicked
Okay.
there.
Did you talk about it with friends and family and coworkers?
Not recently, no.
All right. When's the last time you recall, prior to coming to jury service, hearing or seeing anything about the case?
Few things on the news, just that there was another case, another case or another hearing and that kind of thing, but nothing in detail.
Okay. And as a result of that, you indicated you formed an opinion as to Mr. Lloyd's guilt.
Yes.
And what is your opinion?
I believe that he did it, yes.
Okay. Jurors have to start trials presuming that someone is innocent. It's just what the law requires until and if the state can prove they're guilty beyond a reasonable doubt. Do you believe that you can do that in this case, or would you start believing he's guilty?
Believe just because of some seen on the news.
Okay.
Have those views, it would be probably more of an uphill battle to change my views.
All right. Thank you, sir. State?
No objection, Your Honor.
Defense? All right. Thank you, sir. I don't think this is the case for you. We appreciate your service. You're discharged and free to go.
Thank you.
Juror in seat 46, please. Good afternoon, ma'am.
Hi, how are you?
I'm well, thank you. How are you?
Good.
You've been patiently waiting. I appreciate it. I really do.
Thank you.
Just answer the questions truthfully. We're not looking for a specific answer. We're just looking for what you really think and feel, okay?
Okay.
You indicated that you've heard about this case. Is that correct?
Right.
All right. How have you heard about it?
Well, the defendant was dating someone that I knew.
I'm sorry, you need to,
Oh, the defendant was dating someone that I know.
do you know Mr. Lloyd himself? Or
I don't know
just the
him
person he was
personally,
dating?
but he was dating someone that I knew.
And what was the name of the person he was dating?
Jamesia Slaughter.
Okay. Did you and she talk about him?
Yes.
Did you form an opinion about Mr. Lloyd based on those conversations?
Yes.
Is that a good opinion or a bad opinion?
A bad opinion.
All right. And then you also heard about the case?
Yes.
Is that on the news and just folks talking about it?
Folks talking about it and on the news.
Did you form an opinion as to whether he's guilty based on that?
Yes.
And what's your opinion?
I'm guilty.
All right. You have to presume he's innocent in order to sit as a juror in this case. Could you do that?
I don't think so.
All right. Thank you, ma'am. State?
No objection.
Defense? All right. Ma'am, thank you very much for your honesty. You're free to go. You're discharged as a juror in this
Okay,
case.
thank
I don't
you.
think this is the case for you. All right. Juror in seat 49 to juror number 246. We're still on panel 1. Good afternoon, sir.
Hello.
Sir, the only thing we're looking for is for you to answer the questions truthfully. We're not looking for any particular answer. There are no right or wrong answers to these questions, okay? You said that you heard about this case. How did you hear about it? Right. How much news coverage of this did you watch? Okay. And was this recently or? Okay. Did you also talk about it with friends, family, or coworkers, or everybody? No. Anywhere else that you heard about it? As a result of hearing about it and whatever you heard back when it happened, did you form an opinion as to whether or not Mr. Loyd is guilty? Okay, that he's guilty? All right. Jurors have to start trials presuming someone is innocent. That's just the law, until and if the state can prove they're guilty beyond a reasonable doubt. Do you think you could do that in this case? All right, tell me why you think you could presume he's innocent. Okay, so if you were sitting as a juror, I'm going to give you three options, and if none of them apply and there's a fourth option, tell me what it is, okay? You're sitting as a juror, you're sworn in, case hasn't started yet. Are you sitting there thinking, you know, this guy's probably guilty, but I'm willing to listen and see if I'm wrong about that? That's option one. Option two, this guy's innocent. I haven't heard anything. The state needs to prove to me that he's guilty, and they need to do it beyond a reasonable doubt. Option three is, he's guilty, but if he can convince me otherwise, I'll listen. Do any of those three options apply to you? He's guilty and he needs to convince me. I'll listen. I'm willing to listen to him. All right. Thank you, sir. State?
No objection, Your Honor.
Defense?
No objection.
All right. Thank you, sir. I appreciate your willingness to serve, but this is really not the case for you, so I'm going to discharge you as a juror in this case with our thanks. You can keep the mask. All right. Thanks. Juror in seat 50, panel 1. It's juror number 29. Yes. Yeah, I'm going to do 1, 2, 4, and 15 from panel 2 if you want to bring them in there. Okay. Good afternoon.
Hello.
How are you?
Good. How are you?
Good, thanks. I know it's been a long afternoon for you. Got a few questions for you, all right?
Okay.
Just tell me the truth. Don't worry about, there are no right or wrong answers. We're not grading jurors on their answers, okay? We just need to know what you actually know and think.
Okay.
You indicated you knew something about this case. Is that correct?
Correct. Yes.
Where did you get your information?
It was the local news.
Okay. Do you always watch one channel or another?
It varies. Usually it's, I don't know the name of WESH.
Can you move the mic a little closer to you?
Yeah, it's usually WESH or I think the CBS. I can't remember.
Okay. And how much coverage did you watch?
Oh, I didn't sit and watch, but it was on the nightly news, you know, the general updates I've seen and heard.
Okay. Were family or friends or coworkers or anyone talking about, this is before you came for jury duty, is what all my questions are about. Were they all talking about this case?
Are you talking about in there?
No. Before you all came to jury duty, did your family and friends and coworkers, did they talk about the case with you or in front of you?
No.
No? Did you form an opinion as to whether you think Mr. Loyd is guilty or based on what you heard?
Yes. I mean,
and what's the opinion?
Guilt.
Okay. Jurors have to come into jury to sit as a jury, presuming someone is innocent until and if the state can prove that they're guilty. Do you believe you can put aside your feelings and do that, or are you pretty much?
I mean, I would put aside my feelings if I
You
was
would
on-
what?
I would put aside my feelings if I was
Okay.
on a jury based on whatever information I'm given.
Do you think you could do that?
I would say yes. I mean, I don't know the complete details of everything.
Right.
But yes.
All right, so I'm going to give you a few scenarios. You tell me if any of them apply to you. And if
Okay.
they don't, just tell me that, okay?
Okay.
Scenario number one, you're sworn in as a juror and you think, he's innocent. I'm just sitting here waiting to see if the state can prove he's guilty beyond a reasonable doubt. Scenario number two, you're sitting there as a juror and you're thinking, yeah, I think this guy's probably guilty, but I'm willing to listen to see if he's not. And scenario number three, I think he's guilty, but if he can convince me otherwise, I'll vote not guilty. Do any of those three apply to you?
Yes.
Which one?
2 and 3.
2 and 3?
Yeah.
Okay, thank you, ma'am.
You're welcome.
State?
No objection, Your Honor.
Defense? All right, thank you, ma'am. I don't think this is the case for you. We really appreciate your willingness to serve. You are free to go. The mask is a gift.
Okay, thank you.
Thanks. All right, I'm now switching to panel 2. Juror number 1 from panel 2. This is panel 2. Good afternoon, sir. How are you? All right, sir, I'm going to ask you some questions. Just tell me the truth. Not grading your answers. There's no right or wrong answer. It's just what you honestly believe and feel, all right? You indicated that you knew something about, and just to confirm, your juror number is 199, correct? All right. You heard something about this case, is that correct?
Yes.
And what did you hear?
When it happened,
You got to keep the mic close to your mouth, sorry. I need you to speak up a little bit. I'm having trouble hearing you.
I've seen the news in Orlando.
All right, so you watched TV, you saw the newspapers. Did you pretty much keep up with what was going on, or you just kind of watched it every once in a while? Okay. Since this originally happened, have you seen a lot of coverage about it?
Point, and after
Okay. So based on what you saw in the news, did you form an opinion about whether or not Mr. Loyd is guilty?
yeah,
Okay. So to be a juror in a case, you have to presume someone is innocent. That's what the law requires. And sometimes people can do it, and sometimes they can't. So in this case, do you believe that you could presume he was innocent, or would you be sitting there thinking, I think this guy's guilty?
like in
I'm sorry, I'm really having trouble hearing you. What?
and that change.
Okay, so you think you would stick to your opinion that he's guilty? All right, thank you, sir. State?
No objection, Your Honor.
Defense?
No objection.
All right, sir, thank you for your honesty. I don't believe this is the case for you, so I'm going to discharge you as a juror. Thank you very much for your service. You're free to go, and you can keep that mask.
Thank you.
Thanks. Seat number 2, panel number 2, juror 4047. Good afternoon, sir.
Good afternoon, Judge.
All right. I'm going to ask you a few questions. All I need you to do is tell me the truth. Don't worry about, we're not grading your answers. There's no right or wrong answer to this. It's just whatever you actually feel or think, all right? You indicated that you knew something about this case and that you'd heard about it. Where did you hear about it?
Mostly on the news, media.
All right. And how long ago was it that you heard about it?
When it first broke out, back in when it all started.
Did you see anything after that?
Just after the case, and then once COVID broke, I think it just like faded away.
Yeah. COVID was a rather overwhelming event. And you also indicated you formed an opinion about Mr. Loyd's guilt as a result of watching all of that. Is that correct?
Yes, Your Honor.
And what was your opinion?
I believe that he's guilty.
Okay. To sit as a juror in a case, in any case, you have to be able to presume the defendant to be innocent until and if the state proves they're guilty beyond a reasonable doubt. Do you believe you could do that in this case, or would you start thinking he's guilty?
I still think that he's guilty.
All right. Thank you, sir. State?
No objection, Your Honor.
Defense? All right, sir, I don't think this is the case for you. We appreciate your willingness to serve. You're excused from this case, and as a juror, you can keep that uncomfortable mask.
Thank you, Your Honor.
Thank you. Have a good day. Juror in seat number 4, panel 2, juror 469.
Hold it up.
Good afternoon, sir. How are you?
All right.
You're the gentleman that's planning the staycation.
Yeah.
Okay.
Yeah.
Well, let me ask you a few questions. No right or wrong answer. Just tell me what you think, all right? You said you knew a lot about this case. Is that correct?
Yes, ma'am.
How do you know about the case?
Oh, I remember pretty much when it happened. I seen it on the news and everything, you know. I just followed it on the news.
Okay. Did you follow it pretty closely?
A little bit, yeah.
All right. And after it first happened, did you continue to follow news stories about it or read stuff about it, anything like that?
No, I just watched it when it came up, you know.
Okay. So if it came up on the news, you watched it?
Yes, ma'am.
Are you a regular local news watcher?
Yes, I am.
All right. As a result of that, you said you'd formed an opinion as to whether or not Mr. Loyd was guilty. Is that correct?
Yes.
What is your opinion, sir?
Guilty.
Okay. To sit as a juror, you have to be able to presume that he's innocent until the state proves he's guilty beyond a reasonable doubt. Do you think you could do that?
I think he's guilty now.
All right. Thank you very much, sir. State?
No objection.
Defense? No objection. All right, sir. We appreciate your service. You are free to go. You're excused as a juror in this case. Juror number in seat number 15, panel number 2, and it's juror 255. Good afternoon, sir.
Good afternoon.
All right, sir, just a few questions for you. Just answer them honestly. No right or wrong answers to this. You said that you knew a lot about this case. Is that correct?
Not a lot, but I followed it since it was unfolding in the news.
Okay. So you followed it from the beginning?
Yes, ma'am.
And after Mr. Loyd was arrested, did you continue to follow news stories on it?
Kind of fell off the radar for a little bit, but I followed the trial.
The first trial?
Yeah.
Okay. As a result of all of that, did you form an opinion as to whether or not Mr. Loyd is guilty?
Yes, ma'am.
And what is that opinion?
That he's guilty.
Jurors are required to be able to presume a defendant is innocent until the state proves they're guilty beyond a reasonable doubt. Do you think you could do that, or would you consider him guilty?
I think I would have biases towards that, the
Okay.
guilty verdict.
So would you be more in the camp of, I think he's guilty, but I'll listen to see if I'm wrong?
I'll listen, but I probably come up with the same conclusion.
All right, thank you, sir. State,
No objection.
defense. All right, sir, thank you very much for your honesty and your willingness to serve. You are, this isn't the case for you. You're discharged as a juror in this case. You are free to go.
Oh, okay.
And the mask is yet another gift to you that you probably don't want.
Thank you.
Thanks. All right. Going back to panel number 1, the only other juror who indicated he knew something about the case was in seat 57. It's a she, it's juror number 215, so let's talk to her first, please. No, I'm wrong about that. There's like 3 of them, but I'm going to start with 57. Go ahead. Good afternoon, ma'am. How are you?
I'm doing okay.
All right, I have a few questions for you. Just tell me what you think. There are no right or wrong answers to this. Just try and have a conversation with you, all right? First of all, you indicated that you had heard about this case. Is that correct?
Yes.
How did you hear about the case?
Back when, years ago, it was everywhere, all over the news. So everybody was talking about it.
Okay. And you said everybody was talking about it. Were friends and family?
Yes.
Co-workers?
Yes.
Everybody you knew was talking about
Yes.
this? All right. Did you know anyone that was involved in the case?
No, ma'am.
After that initial, he was arrested, did you continue watching stories about it?
Yes, because it was all over the news.
Okay. So throughout the years since, it was 2017, from then until now, have you pretty regularly watched stories on this case?
No.
No? When do you think's the last time you saw anything?
I think that when the last trial happened.
Okay, did you watch the last trial or follow it?
I watched some of it, yes.
Okay. Based on all that, ma'am, have you formed an opinion as to whether or not Mr. Loyd is guilty?
In this case?
Yes, ma'am.
No, ma'am.
Okay. Do you have any inclination one way or another?
No, not unless I hear everything that happened.
In order to sit as a jury and as a juror in this case, you would have to presume that Mr. Loyd is not guilty and that he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Can you do that?
Yes.
All right. Let me talk to you a little bit about the death penalty. Do you have thoughts and position on the death penalty?
I don't think I have either way. It just depends on the circumstances, I think.
Okay. So are you someone who has any moral, political, or religious objections to the death penalty?
No, ma'am.
Do you have, are you someone who believes that at any time someone is convicted of first-degree murder, they should be sentenced to death?
No, ma'am.
In this case, if you're seated as a juror, and if Mr. Loyd was convicted of first-degree murder, you would then go into what I call the penalty phase. State's going to present aggravators, reasons they believe he should be sentenced to death. Defense presents mitigation, reasons they believe he should be sentenced to life. You go back in the jury, I give you the jury instructions after all the evidence is presented. You go back in the jury room with your fellow jurors and you all weigh these aggravators and mitigators. And in the end, you have to make an individual decision as to whether life without parole is the appropriate sentence or death. If the evidence led you, and the facts and everything you'd heard in the case led you to believe that life was the appropriate sentence without parole, would you vote for that?
Yes.
And if it led you to believe that death was the appropriate sentence, would you vote for that?
Yes.
All right. As I told you all, Mr. Loyd has raised a defense of insanity. Could you listen to that with an open mind?
Yes, ma'am.
And not make up your mind until you've heard all the evidence about it?
Yes.
And if you thought the evidence was established that he was insane at the time, could you find him not guilty by reason of insanity?
Yes.
All right, and lastly, as I told you, the conviction on Ms. Dixon's case can't be used by you to determine he's guilty of this case. You understand that?
Yes.
I'll explain later on, if you're seated as a juror, what that evidence is being offered to prove. Can you do that? Can you put that aside and not use that to determine guilt?
Yes, ma'am.
Do you have any doubts in your mind about your ability to sit on this jury and be fair and impartial to both sides?
No, ma'am.
All right, thank you, ma'am. I'm going to turn this over to the lawyers. Mr. Williams, you may inquire.
Yes, Your Honor. Good afternoon.
Good afternoon.
So I want to start by asking you some questions about you having watched the first trial. Did you actually watch the closing arguments on TV or something?
I only watched some of it because during working hours.
Right, because you got things to do. Yes, ma'am. Were you aware of the verdict prior to the judge telling you here today?
Yes.
That he was convicted?
Yes.
Do you know whether or not the state sought the death penalty in the first case?
I don't.
You don't? Okay. So you told Judge Marquez that you didn't really have an opinion on the death penalty one way or the other. Did I hear you say that correctly?
Yes.
All right. I feel like we just threw a bunch of law books at all of you sitting over there with all the information we just gave you. Did you hear the judge provide an explanation of sort of the process of how this will go through?
Yes.
Did you feel like you have an understanding of that?
Yes.
The reason I'm asking is I'm not going to go through it all again if you feel like you have your arms around it.
Yes.
Okay. So, but I do want to ask, have you ever heard of, as somebody who watches the news, a case or a set of circumstances where you thought to yourself, that is a crime, that person deserves a death penalty? Like
I have.
You have? Mm-hmm. Okay. Can you tell me about that circumstance, please?
It was on court TV years ago where children were killed.
Children?
So, yes.
Okay. Was it more than one child?
Yes.
All right. And that's as you can imagine, a very common response. People are sensitive about kids.
Yes.
Do you have any kids?
I don't.
You do not? Okay. And I saw that you said you didn't have any under 18, but I wanted to make sure.
No, I don't.
Okay. But nonetheless, somebody hurting a child, that personally offends you. Is that a fair statement?
Yes, because I have 13 nieces and nephews that I love with everything in me.
Say that again, please.
I have 13 nieces and nephews that I love with everything in me.
Okay, so no children of your own, but you're certainly no stranger to kids.
Right.
Understood. Okay. Well, this case doesn't involve children, right? And I want to make sure I understand what I heard you say is that even though you may have had an opinion on the defendant's guilt in the first case, you have no opinion in this case.
Right.
And so you understand there's a difference between this case where it's alleged that Lieutenant Clayton has been murdered versus the past case.
Yes.
Can you separate those two things, compartmentalize them in your mind, and make a decision based only on what you hear in this case?
Yes.
All right. Would you, on a scale of 1 to 10, how much would you want to be a juror in this case?
I don't want to be.
You don't want to be?
I don't.
So it's a 1 for you?
A 1.
Okay. Can you tell me why that is?
I just don't want to be. I just don't want to be here.
Because of the nature of the decision, or you have other things to do? Or?
I have other things to do, honestly.
All right. Do you think that you would be able, given that you don't want to be here, to give us your full attention over the course of 3 weeks?
I will.
You will. All right. So you don't want to be here, but if you have to, you'll be all in. Is that a fair
It's my
statement?
duty.
It's your duty.
So.
Okay. Thank you for telling us that. One of the things that the judge described is that if and only if Mr. Loyd is convicted of first-degree murder, and will present evidence of aggravating factors. And those are things just like they sound, things that about the way a crime was committed or the nature of the victim that make that crime eligible for the death penalty when other first-degree murders may not be. Did you hear her say that?
Yes.
All right. Other than the child, well, let me back up. Even if it's the murder of a child or multiple children, that crime is not automatically eligible. You understand?
Yes.
There are certain things that have to be proven and found and weighed before we get there. I think you understand.
Yes.
All right. So my question for you is, you've been told that this is the murder of a law enforcement officer. Does anything about the nature of the law enforcement officer aspect of this crime present a particular issue for you?
No.
Have any members of your family that are in law enforcement or friends or loved ones or anything like that?
No,
Okay. Well, I'm assuming you respect law enforcement?
I do.
You do. But that in and of itself wouldn't prevent you from being fair and impartial?
No.
Okay. Even in a case where, let's just say, hypothetically, children were killed, any criminal defendant, including Mr. Loyd, has the right for jurors to listen to those mitigating circumstances. And those are things about his character, background, or life, anything in his life, that the defense will present to you if they choose, and you'll need to give meaningful consideration to. You don't have to agree with it. You don't have to find that it's mitigating, but you do have to meaningfully consider it before you make a decision. Do you think you could do that?
Yes.
Right, okay. Now, the other topic that was raised or broached was the issue of insanity. Without being too personal, if you can answer this, have either you or someone close to you had a mental health issue, a significant one, that affected their life in some way?
No.
No, so that's never been something you've encountered?
No.
All right. I'm assuming you mentioned Court TV earlier, that you've probably heard of the defense of insanity before. Right. So when you hear that somebody is claiming that they were insane at the time of the crime, and therefore that they should not be held responsible, you understand that that's what that means?
Yes.
Okay. What are your thoughts when you hear that?
Most of the time, I just think it's a defense.
Okay. And by just a defense, what do you mean?
I don't think they're insane.
Okay. So when you hear that somebody says that they're insane, am I accurately restating it that you're skeptical?
Yes.
Okay. And why is that?
Because they don't want to go to, I feel like they don't want to go to jail. And if it's a defense they can use.
Okay. And I'm picking that up from you. I just want to make sure that I understand what you're saying. Do you believe that there are legitimately people with mental illness issues in this world? Do you believe it's possible that a person could be so mentally ill that they didn't know what they were doing or that it was wrong? In other words, you do believe that some people are insane legally. Given that you are skeptical of that defense, could you assure us that you would still be able to listen to the evidence on that fact, on those factors, and fairly and meaningfully consider it before reaching a decision on that topic? Yes, okay. Any concern about that at all? Last question, and you sort of alluded to it, like you told us that you had 13 nieces and nephews. That's not something I would ever know about you unless you told me, right? Is there anything in your life or background that you think we should know about, given that we as a group are trying to select the most fair and impartial jury for this person to get a fair shake in our system? Usually, if there's something out there, it pops in your mind, and I'll give you an example. Some people say, you know what, my best friend was murdered 20 years ago, or I had a loved one who was killed or the victim of a crime. Anything like that that you can think of?
Oh, yes.
Can you tell me about that?
I have 2 loved ones that was victims of murder from domestic violence, yes.
Okay, you had 2 loved ones that were murdered?
Yeah.
All right. And I'm sorry, but I'm going to have to ask you, okay? How long ago was that?
DG was years ago, probably in 1992 or 93. And Jasmine was not so long ago, maybe about 40 years ago.
So 4 years ago would have been not too much before, or right around the time this happened?
Yeah.
It
was, I can't even remember. I don't know, you might even remember Jasmine Samuels. I don't even think her murderer has been a trial yet.
You don't think the case has gone to trial yet?
No.
Okay, is that here in Orange County?
Yes.
Forgive me for not knowing, I apologize. Again, I'm sorry to have to ask you, but were you close to these 2 individuals?
They were family. We weren't super close, but they were family members.
Did you say DJ was the first one?
DG.
DG, okay, and that was about?
About 92, 93.
Who was that person to you?
She was a cousin.
The facts surrounding his death? In other words, do you know how he died? It was a female, I'm sorry. Do you know how she died? And how do you know that?
Boyfriend killed her.
Okay. Did you read police reports, or did you see it, or did someone tell you that?
Oh.
You were told. Okay. Given the nature of that, and that you know that Mr. Loyd has been convicted of killing his girlfriend in the past, do you think you could still be a fair and impartial juror for Mr. Loyd?
Yes.
So you could set us, go ahead.
Yes, because it wasn't the same circumstances.
Okay. I understand that, but you realize why I have to ask. The second circumstance, that was also a female? All right. Was that a boyfriend-girlfriend thing?
Yes.
Right. And so is it alleged that that male killed your, and who was she to you? DG. Oh, so I see. I think I know the individual that you're speaking about now. Yes, ma'am. Anything about that situation with DG's daughter that would prevent you from being fair?
No.
It's very important, and like the judge said, there's no wrong answer for you to look deep inside yourself, because you're the only one who can, that you can set aside those two set of circumstances. Can you do that for us?
Yes.
All right. And I know you're being honest because you don't want to be here, right? So,
I don't. I really don't.
Okay. Last question, okay? Or it's two questions, I'll be fair. Let's say you go through this whole process and you find that we haven't proven the aggravators beyond a reasonable doubt, or that the mitigation you hear about Mr. Loyd's life is really meaningful and important, and that you think life is the appropriate sentence for him. Could you go back to the jury room and raise your hand and vote for a verdict of life without possibility of parole?
Yes.
Conversely, if you believe that we've proven at least one aggravating factor and that a sentence of death is appropriate in your mind, could you raise your hand, not in a hypothetical sense, but in a very real sense, to vote to impose a sentence of death on another human being?
Yes.
Okay. Did I miss anything? Okay. Thank you very much, ma'am. Thank you.
Mr. Williams. Mr. Lenneman, you may inquire.
Good afternoon, ma'am. How are you? Now, I heard your response.
Yeah.
In terms of the law, is very clear that you are the one that makes the right decision. That is the other one of the jurors. That is the question each of you made the compensation of that. Okay? The way that happens is you would listen to all the evidence in the first part of the case. Assuming that Mr. Loyd is found guilty, you go to the second part of the case, and at the end of the presentation, they will present set instructions to the law. And what that requires is all the jurors first thing all the have to do is find that there was at least one aggravating factor that was proven beyond a reasonable doubt. Okay? Understand? That's the only thing jury complete. Everything else is individual decision making. So, in other words, the next step is you have to decide what aggravators is and then give them the way you need to jury. And then the mitigators that will prevent the proven to a lesser standard than you have to decide if it's proven. You give the weight to each and every one of those, the way you decide. You can give one great weight, another small, you can add them all up. And at the end, you can weigh aggravators against the mitigators. You understand? So, once you weigh the aggravators and the mitigators, you leave the mitigation decision-making processes are independent. Okay? You can do that? I have nothing further.
Other side need to approach?
No.
No, Your Honor.
All right, ma'am. We're going to bring you back for the last day of questioning, okay? And that means we're going to give you a packet, and you're now a purple dot. So if you'll take your badge and hand it to Ms. Teresa here, she's going to give you a purple dot. We're giving you a sequestration package because if you're picked for the jury, you would be sequestered. We need you to pack, when you show up the next time, we need you to have packed the night before. Leave your suitcase in your car. You won't need it unless you get picked as a juror. We don't know when that's going to be, but I can tell you it won't be before next week. So what you're going to do is we're also giving you in the packet a slip of paper that's got a phone number that you can call. Don't even bother calling until Thursday. Then just call every day. When you hear purple dots report on such and such a date, that's you, okay? And the packet explains to you what to expect as a sequestered jury. Again, this is all in case you get picked for the jury. Do you have any questions? All right, thank you, ma'am. You are free to go. Juror in seat 38, juror number 30, panel 1. Good afternoon, sir.
Good afternoon.
Sir, are there any issues with your job?
No, not with my job. I did have a chance to take a look at my calendar. I'm officiating a wedding on the 23rd. It's a Saturday,
Okay,
6 p.m. And I've got my second COVID shot on the 28th of this month,
okay,
and that's it.
that's it. Those are the two things that you have. If you weren't there at the wedding, is there someone else who can officiate?
Could ask around, I guess.
Are these friends of yours, family,
Yes, friends.
friends? Okay. And how long have they been planning their wedding?
I'm not sure.
Okay. Have you heard anything about this case?
When I got home on Friday, I saw some of the news stories on my news feed, and it jogged some memories of a case maybe 4 or 5 years ago. I'm not sure how far back it was.
Did you read the stories on your news feed? Because you weren't supposed to read anything.
No, it was just on my news feed.
So what did it jog?
Just a memory of a young woman who was pregnant that was shot and killed.
Yep. So based on that, have you formed any opinions about Mr. Loyd being guilty?
No, ma'am.
I'm sorry?
No, ma'am.
Do you think you could, as I told you, he was convicted of the murder of Sade Dixon and her unborn child, and he was sentenced to life, but you can't use that to determine whether or not he's guilty of these charges. That information is being provided for a different reason, that if you're on the jury, we would tell you what it is. Do you think you could put that aside? Because you cannot use it to determine if he's guilty.
Yes, I can put it aside. It's understood.
All right. Tell me what your feelings or thoughts are about the death penalty, please.
Personally,
Yes, sir.
yeah, personally, I'm not an advocate of it.
Okay.
I've never been in a situation where I've had to exercise my personal beliefs.
All right. So do you have a religious or moral objection to the death penalty?
No.
No. In a case like this, if Mr. Loyd was convicted of first-degree murder, then you would have to make a decision between life without the possibility of parole or death. And that's the penalty phase. You know, the state's going to present aggravators. They're going to present evidence of aggravators, reasons they believe death is appropriate. Defense is going to present evidence of mitigation, reasons they believe life without parole is appropriate. I give you the jury instructions, and you and your fellow jurors retire to that jury room to talk about it. You're going to weigh the aggravators and the mitigators, and then you have to make a personal decision as to whether you believe the appropriate sentence is life or death. If at the end of this whole process, you had all the evidence, all the facts, everything has been given to you, and you believe that all of that led you to a life sentence without the possibility of parole, would you have any problems voting for that?
I would have no problems voting for that.
Right. If it led you to believe that the appropriate sentence was death, would you be able to vote for that?
I would be able to vote for that.
Okay. Do you have any concerns about your ability to vote for that?
No, ma'am.
The defense of insanity, as I told you, has been raised. I read you a little bit of the instruction on that. Can you listen to any evidence that's presented on that issue with an open mind?
Yes, ma'am.
And if you felt that the evidence established, by clear and convincing evidence that Mr. Loyd was insane at the time of the offense, would you be able to find him not guilty by reason of insanity?
Yes, ma'am.
I think I probably already asked you this, but forgive me, I've been doing this all day long. So remember I told you can't use the murder of Ms. Dixon and her unborn child to determine guilt, and you're fine with that. You can put that aside? You told me that, right, didn't you? Yeah.
Yes, ma'am, I answered that.
Okay. Is there anything right now that would cause you to believe that you would not be able to sit as a juror in this case and be fair and impartial to both sides?
No, ma'am.
All right, thank you, sir. I'm going to turn this over to the state. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon. Almost evening, sir.
Yes, sir.
So the way you phrased one
but I do not personally support the death penalty.
Okay, so can you tell me why it is that you don't personally support it? I'm not assuming that you should. I just want to know what your opinion is. As to why.
It's hard for me as a single individual to feel like I could cast judgment on someone whether they live or die.
Okay. As a single individual, meaning one person having that sort of authority over someone else's life?
Correct.
Have you ever heard of a situation, whether it be in the media or from a friend or from any source whatsoever, where a person committed a crime or an act that when you heard about it in your mind, you thought that that person should die, legally or otherwise? Have you ever heard of a situation like that? And it's okay if you have.
Yeah, sure. I've watched plenty of World War I and World War II documentaries. We hear about all kinds of rotten stuff going on in this world. Okay.
So you brought up World War II. You're talking about things maybe like genocide.
Sure.
Right? So you can, if I'm wrong, correct me, okay? But what I hear you saying is you can imagine if a person murdered hundreds, thousands of people, that it might be appropriate for that person to be sentenced to death.
Yes.
All right. Short of genocide, and I'll be more specific, like the killing of one person, can you imagine a scenario in your mind where you think that the way that the murder was committed or maybe the nature of the victim might warrant a sentence of death?
Yes, I can imagine that.
Okay, can you tell me which situation you're thinking about? Or a specific one that you can...
I'm not thinking of any specific situation. You asked if I could imagine one.
I did, to be fair. Okay. Is there any, slightly different question, is there any situation where you think the nature of the crime would in your mind almost automatically lead you to want to impose or vote to impose a sentence of death? Let me give you an example. Some people, particularly those who have children, say to themselves, if you murder a small